Alright, decent We the People News, one more time at it. So this video is on all the others previous is educational. It's not intended for legal advice. Do your own research, okay? Anything I say or do is hearsay. So that being said, never look straight forward. Always look around you to be able to protect yourself by any means necessary, okay? Use the Second Amendment, arm yourself with knowledge, and even though it's an uphill battle, always fight everything for yourself. Okay? Quit having other people do your dirty work. Quit being like attorneys and judges and all that and just, banking on somebody else to be the criminals while you get to hide in the back and never be punished. All right. Just saying, people. Let's go.
It's so preposterous.
Okay, you don't need to explain. Sir, you don't need to explain. Okay, let me get on to the next question. Do you realize that if you represent yourself, you are on your own and the court cannot tell you how you should try your case or advise you as how to try your case?
Yes.
Okay, thank you. All right. Are you familiar with the rules of evidence? Somewhat? Okay. All right. Are you familiar with the rules, or excuse me, so I also need to make sure that you understand that the rules control what questions can be asked of witnesses, how questions must be phrased, and what documents or other items can be admitted at trial. And in representing yourself, you must follow these rules, and these rules apply in the same way they would apply to an attorney. So do you understand that, sir?
I understand the statement. I would say from personal experience that the attorneys have violated the rules on a regular basis, as have judges, but I follow rules.
Okay, so this is about...
You guys got to read that, pause it, and all that, and understand what he just said. Right? He's calling them out. You're telling me that I must comply with all these rules, and you guys get to ignore it. And you guys get to throw me in jail, and you guys are still free for being criminals.
So you understand, though, that you're held to the rules of evidence, correct?
Yes.
Okay. All right. Are you...
Now she changed it, right? When he did that, now you're held to understand the rules. Before then was, you did the same standards as the attorneys. Now it's just you are.
Familiar with the rules of criminal procedure?
Yes.
Okay. Okay, and then let me read the following. These rules govern the way in which a criminal action is presented in municipal court, and they control the presentation of the case. These rules apply to you the same way they would apply to an attorney. So I want to make sure that you understand that.
I understand.
Now understand this as well, y'all, and this is what we're overlooking as well, right? Municipality, right? Municipality is administrative. Okay, you got to see a real judge for criminal, which they're just ignoring.
All right, thank you. All right, and let's see, do you realize that if you decide to take the witness stand, you must present your testimony by asking questions of yourself, and you must proceed question by question through your testimony, so the prosecuting attorney has an opportunity to object before each question is answered. Or more simply put, you cannot just tell your story. So do you understand how that would work if you were to take the stand?
I do understand it.
I have to say, y'all, I think we still would, instead of ejecting, I think some of these things would just plain out deny. I deny said claim. I don't object to it. I plain out deny it. Well, denial is more of a burden for the other side to prove. Objection, what is this judge doing? Oh, your objection is noted, your objection is noted. But when you actually say, I deny they have subject matter jurisdiction, now the burden is really heavy on them.
Last time I tried to take the stand, I was denied that right by Judge Lynch for the record.
All right. I'm moving on. Do you realize that an attorney would be familiar with the rules of evidence, skilled in following the rules of criminal procedure, and could advise you of possible defenses to the pending charges?
I do.
Thank you. All right. Do you realize that if you proceed without an attorney and you do not properly present a defense, subpoena witnesses, or otherwise represent yourself in a competent manner, you will not be able to obtain a reversal of a conviction on the grounds that you received ineffective representation?
I do.
Right.
See, and because you represent yourself, they retaliate against you and give you a stiffer fee. So if you get an attorney, well, we're going to make a plea of 10 years, but if you represent yourself, we're going to give you 20. And because you may goof up somehow, that you don't have an opportunity to kind of go back in there and appeal that case. But if attorney goofs up somehow, they get to go back in there and do it.
Thank you.
Which, by the way, that's not a bad idea.
Okay, and then just briefly, sir, why do you not want an attorney?
I didn't say I don't want an attorney, Your Honor. I don't want an attorney who works for the Department of Public Defense.
Okay, and can you tell me then maybe why you don't want an attorney from the Office of Public Defense?
Yeah, because they are constrained apparently by their superiors from offering competent defense representation. For example, their customs policies, practices, and procedures preclude them from filing a habeas petition on my behalf, even when I've pre-written it for them. From our experience, I also know that even in a case where the city had destroyed the exculpatory evidence in violation of Brady v. Maryland, that even when I pre-wrote a motion to dismiss, that the policy of the DPD was to not file that, nor even argue it. So, unfortunately, the DPD is not set up and does not operate in a manner that I find to be effective counsel.
Okay.
I don't have any problem at all with Mr. Reagan Roy as a person. I think he's a good person, but I think he's limited by what he is allowed to do in relation to his employment.
Okay, so I see what you're saying. So okay, so you're choosing not, you don't want a DPD attorney, and then you want to represent yourself now, and then you've also indicated that you may hire private counsel.
Right.
Okay,
I expressly reserve my right to hire outside counsel.
I understand.
But as I said before,
Mhm.
I have been denied the right to even communicate with a potential attorney without having the call recorded.
Okay, so let me back you up just one moment. So I want to make clear, if I allow you to represent yourself, that's fine. And again, I want to repeat what I said earlier. The city will then be communicating with you directly.
Yes.
If you hire private counsel, that person needs to make a notice or file a notice of appearance, in which case the city would need notice, and then they would know that they would not be able to be in communication with you. Okay, so everything has to be on the record so everybody understands what's going on. Okay, all right. And then let me move on. Do you realize that once you waive your right to an attorney, it is discretionary with the court whether you may withdraw the waiver? So.
Well, I'm waiving my rights to have the DPD represent. I'm not waiving my right to counsel.
Okay, I think this question really means that if I allow you to represent yourself, so that's a waiver of your right to counsel is what we're going through. So it has to be, I think it's basically, it's discretionary with the court to allow you then to switch back and have someone representing you. It's kind of like what I was just saying. I just want to make sure that we're all on the same page. If you hire counsel, the court's going to need to know that that's happening.
I
understand what she's saying, as well as he's just fixing to say. It kind of makes sense out loud and maybe on paper. But really, if I find myself in a bad situation, then I may need to bring somebody in. It's like, okay, I'm over my head. Could you help me in this process? Okay. But that's what a counsel is to help, not speak on your behalf, but to help you through it. And this is where our common law rights of counsel has been misconstrued and all mucked up and dirty, right? So I have a right to attorney or I have a right to counsel. But technically, by the Constitution, I have a right to counsel. I do not have a right to an attorney.
And it sounds like you're reading from a city-produced form and that you're going through that. And I understand that that's how it's written. And
No, this is a court form, sir. We use this. It's a court form.
right, but it's a court form for Seattle Municipal Court, which is a court of limited jurisdiction. And I've already articulated numerous instances how Seattle Municipal Court violates the law. So
Okay, so Mr. Benjamin, how do you want me to answer that question? So let me read it to you in that, because I don't want to put words in your mouth. So it says, do you realize that once you waive your right to an attorney, it is discretionary with the court whether you may withdraw the waiver? And so
I understand that's the court's position.
Okay.
Look at that perfect words right there, right? I understand that that's the court's position. Good stuff right there.
All right.
I hope the court understands that my objection to the lack of jurisdiction means that the court doesn't actually have authority to do anything.
Okay, I understand, and I did earlier say that I was noting your objection that you would have an opportunity to brief and argue your position on lack of jurisdiction at a later time.
There isn't.
And again, no, this is the perfect time so it does not proceed forward. Look, for taxpayers, okay, if you want to call yourself that, right? It's costing taxpayer money right there. Costing taxpayer money right there. Costing taxpayer money, taxpayer money. That she has zero authority to keep going. This actually is a good time to have a dismissal with prejudice of due to like subject matter jurisdiction.
Issue with my gulag incarceration in King County Jail, which is I have no access to pro se materials. I have no access to the internet. I have no access to a computer. I have no access to a printer. I have no access to even a single piece of paper. It's not scratch paper that I've stolen from somewhere else, basically. Not stolen, but reappropriated. I have no access to envelopes. I have no access to stamps. So while you several minutes ago mentioned that I need to make sure that I put stuff on the record, for the record, I am unable to put anything on the record because of the incarceration conditions. They've kept me for more than a month on floor 9, which means that I don't even have access to anything at the commissary. So even if someone put $1 billion on my books, there is no way for me to get an envelope from the commissary to my room so that I could put a piece of paper in it to mail back to the Washington Supreme Court, which has already sent me legal mail, as well as the U.S. District Court has.
Okay, well.
And right there is a violation of due process. Since it's a violation of due process, what does that mean? Like a subject matter jurisdiction.
At this point,
I don't care if it's the judge's fault or the jail's fault. There's a due process violation that he does not have access to.
Until now, I don't think that because you have not been formally representing yourself, I'm not sure. Well, okay, so Mr. Benjamin, hang on just a minute. Okay, all right. So I understand that you haven't had access to research materials, things to brief. So if you're going to be representing yourself, then going forward, we will have to address that. So
yeah, and so page 26 of the inmate, King County inmate booklet says that in a criminal case, the judge will issue a court order permitting you to act as your own attorney or pro se, and then I must use a white kite to submit a copy of the court order to inmate management services. I've gotten multiple excuses from King County Jail staff as to why I haven't been afforded pro se materials and services, but I would ask the court at minimum today issue an order with all 10 of those case numbers on there stating that I have pro se status so that the jail can't any longer deny me access to materials.
Okay, so yes, so once this happens, they will be notified that you are representing yourself. Okay, so Mr. Bencher, we're almost to the end here. Let me finish up the last few questions. Do you realize that while the court may provide you with an attorney as a legal advisor or standby counsel, you do not have an absolute right to such assistance, and you, not a standby counsel, must prepare for trial? Okay, so
we're going to stop right there. That's not what the Sixth Amendment says. It says you do have a right, okay, assistance and counsel. Okay, now that being said, and don't nitpick at free or not free, okay? So I had to relook at it. It's been a long time, so there may be discrepancy within that. But usually what they do is charge you for a counsel later to violate your rights and help the judge out. Meanwhile, he's going to try to get you to do a plea so that way you can be on record that you committed the crime. So that way you can get out of jail or have less sentence, or the judge is going to retaliate against you and put you in there for 20 years instead of 10.
you're asking for standby counsel? I didn't hear you say that, so okay. Okay, that's fine. All right, and then have any threats or promises been made to you to induce you to want to represent yourself? Okay, now, in light of the penalty that you might suffer if you're found guilty, and in light of all the difficulties in representing yourself, is it still your desire to represent yourself and give up your right to be represented by an attorney from the Department of Public Defense?
Yes.
Yes, okay. And then one last thing, is this decision entirely voluntary?
See, and this is the trick of words they play on us, right? She plain out said up here a while back, right? You do not have an absolute right. But then she turns around and says you do have a right. Okay, you either have a right or you don't have a right. There is no between in there. Because you cannot change a right into a privilege. But they go with these trickery of words. You don't have an absolute, right? You don't have an absolute First Amendment. Well, yes, you do. As long as there does not create a victim. But they give this a future reading that you may create a victim. So it turns into not an absolute when that's not what it says.
Voluntary on your part?
Yes.
Sorry? Yes, okay. All right, thank you. Okay, and so okay, I'm just going to note that I went over this verbally with you, Mr. Benshoof, today.
All right, I'm going to end it here. This will be the People News. Bye, y'all.